In recent developments, former Trump Chief of Staff, Mark Meadows, is embroiled in a legal battle to transfer his trial from Georgia to federal court in Washington, D.C. An intriguing question arises: why hasn't former President Trump pursued a similar legal maneuver? The answer lies in a calculated waiting game. The strategy behind Trump's reluctance to request a change of venue stems from the prudent approach of observing the outcome of Meadows' attempt. The arguments put forth in both cases bear striking similarities. Therefore, Trump's legal team is monitoring Meadows' proceedings closely. If Meadows succeeds in transferring his trials successfully, it sets a precedent that could be advantageous for the former president. One pivotal reason for this cautious stance is the recognition that Trump, known for his propensity to bend the truth, would face significant challenges if called to testify in his own defense, as Meadows did. The prospect of the former president taking the stand in a similar hearing is implausible. This reality underscores the careful deliberation at play in Trump's legal strategy. Meadows, on the other hand, is advancing a unique defense argument. He contends that his involvement in election interference in Georgia fell within the scope of his official duties. This assertion, while strategically crafted, raises eyebrows among observers who find it hard to reconcile a government official's interference in a political campaign with the responsibilities of their position. Author Chris Whipple has sounded a warning regarding Meadows' argument, suggesting that it serves as an ominous foreshadowing of Trump's potential second term. Whipple asserts that should Trump return to office, he could push the boundaries of the Constitution in unprecedented ways, potentially eroding democratic norms and institutions. The delicate balance that Meadows must strike in threading this legal needle is apparent. To the layperson, his defense might appear counterintuitive. How can a government official, tasked with upholding the law, justify interfering in a political campaign? Nevertheless, as former White House Chief of Staff Julian points out, Meadows can argue that he was merely following the president's lead in his capacity as Chief of Staff. This nuanced argument forms the crux of Meadows' legal defense, even if it challenges conventional wisdom. The conversation then turns to the political landscape in Georgia, where Governor Kemp has broken ranks with fellow Republicans by allowing the Fulton County case to proceed. This divergence within the Georgia GOP has the potential to shape the political dynamics of the 2024 race. Governor Kemp's decision to distance himself from Donald Trump's influence is notable. Unlike Governor DeSantis in Florida, Kemp has drawn a distinct line in the sand. The consequences of this break remain uncertain, but it does signal a commitment to principled governance, even if it goes against the grain of current Republican trends. This move by Governor Kemp is emblematic of a broader divide within the Republican Party. As the 2024 race approaches, many Republican Secretary of States and governors are expected to align with Trump, given his continued leadership within the Republican ranks. The ultimate question for Republicans is how they will navigate this political terrain. This presents a moral conundrum for the GOP. Where will their moral compass guide them as they approach the general election? These are challenging times for a party grappling with internal divisions and external pressures. In conclusion, the legal strategies surrounding Mark Meadows' trial venue and the political divide in Georgia reflect the complex and evolving landscape of American politics. As legal battles unfold and the 2024 election looms, the choices made by key figures within the GOP will play a defining role in the party's future trajectory.